Important about the important about the RTI Act. What is about the RTI Act? So recently government passed a provision for the RTI, right to information. So right to information, and that was in 2005. Okay, so that was chief election commission and not more than 10. So 1 plus 10 will be the ratio. One is chief information commission, other will be the information commission. Okay, and they are appointed by the president. They are appointed by the president of India. President of India. They are appointed by the President of India, consisting of the committee, and there will be a committee. That committee will be going to be made of this. So one will be the Prime Minister, now leader of opposition. Now other person is the opposition in Lok Sabha and Union Cabinet Minister, and Cabinet Minister will also be there, and by the Prime Minister, nominated by the PM. It will be nominated by PM. This will be the committee, and it will decide about the president on the recommendation of the committee, who will be the chief election commissioner. Okay, they should be person of eminence in public life. So what is importance in that? First is the person of the eminence in the public life. So person of eminence in the public life. First is he should be eminence in the public life, and second, wide knowledge of the experience of the law and science and technology, social service, we can say about the social service. Okay, and journalism and mass media, and they are not eligible for reappointment. So reappointment is not provided for. No reappointment will be provided to the Chief Information Commission. So what about the RTI Act? What about the RTI Act? Okay, so first is removal of the fixed term. So fixed term is provision is given. The government will notify the term of office, and salary will be determined at the central level, and salary at the central level, and will be equivalent to the paid to the Chief Election Commission and Election Commission. Chief Election Commission को जो salary दी जाती है, that salary will be provided to the Chief Information Commission also. Okay, and at the state level, equivalent salary paid to the Election Commissioner and the Chief Secretary, and that will be at a state level. It is going to the Chief Secretary of the state. Chief Secretary of the state. So the amendment empower the central government to determine the salary allowances and condition of the services. So what are the RTI rules? Define about the RTI rules. These are it grant the absolute power for government conditions of the services. That is about the conditions of the services. Okay, under the rules, and in such cases decision of the central government is binding, and decisions are binding, and government has a power to relax the applicability of the rules. Okay, so this is about the final interpretation of all rules is with the central government in this. Now recent judgment related to the RTI. What are the recent judgments? So RTI के related है. Okay, so first is Central Public Information Officer plus Supreme Court of India, and the case is Subhash Chandra Agarwal case. This one is a case, Subhash Chandra Agarwal case. In this, five judges of the Constitution declared that the CGI is a public authority, and they told about the CGI that is a public authority. He is a public authority, है ना? And under the section 2H of the RTI Act, that is told that CJ is a public authority, and information about the personal asset of the judge is not a violation of their right to privacy. If we are taking information, that is not the violation of the privacy, not the violation of the privacy. Okay, that is not the violation of the privacy. And following information cannot be disclosed. So reason cited by the collegium. First we should give the reason by the collegium system. Okay, and then information protected under section 8 of the RTI Act, and that is protected under the section 8 of the RTI Act. Okay, this is protected. So Dev College Trust and Management Society, what is about Dev College Trust and the Management Society, that is Supreme Court ruling has both non-governmental organization receiving fund from the government under ambit of RTI. Now second case is like NGOs are there and they are taking the funds from the government under the RTI Act, okay. So this is the currently NGOs are regulated under the provision of the Foreign Contribution Regulation FCR Act, Foreign Contribution Regulation, and the FEMA Act. FERA and the FEMA Acts are there. And in this ruling would be means that NGO will be have to maintain records as provided under the RTI. An NGO shall maintain the records if they are provided to the RBI. If RTI is asking, then they should have some records also. So NGOs are the substantially funded by the government will be considered the public authority, and whether NGOs are sustainable government financing will be examined the case to case basis, and that will also examine the case to case basis, that is the funding, okay. And the substantial funding can be in both direct and indirect way, and funding can be in the direct way and in the indirect way also. And while the determining substantial funding, the current value of the land will also have to be evaluated, and land की जो value है current, that should also be evaluated in this application, okay. So what is about the section 2H of the RTI Act? What is about the section 2H of the RTI Act? Okay, so the 2H, the section 2H of the RTI Act, section 2H of the RTI Act, and this is about the public authority, means the authority or body institution self government. If there is a self government, that means it is a public authority, that means it is a public authority, and that is under the 2H. By under the constitution, it may be under the constitution, it may be made by the parliament, it may be made by the state legislature, or by notification of the appropriate government, or last one is from the notification. So body owned, control, or substantially financed non-governmental organizations are substantially financed directly, indirectly by the fund provided by the appropriate government. It is provided by the appropriate government. And RTI Act does not define the substantial financing, okay. RTI Act does not define the substantial financing is not defining, but Supreme Court in its judgment have widened the definition, and the section 8 of the RTI Act, and the section 8 of the RTI Act, section 8J of the RTI Act, that was say the personal information. First is the personal information, and relationships are which would be cause the unwarranted invasion of privacy. So appellate authorities satisfied that larger public interests are there to disclose the information. First, the disclosure of the information, so larger public importance, public interest should be there. So any person who is a citizen of India, first is he should be a citizen of India, and that is under the RTI Act, okay. All below poverty line families are exempt to paying the fees, and nominal fees is 10 rupees only, but the BPL are not they are not allowed to pay the fees, okay. Now the next one is Foreign Contribution Act. Next one is Foreign Contribution and Registration Act 2010, FERA Act, okay. So this act was regulate the acceptance, utilization of foreign contribution. If you are accepting acceptance or utilization of the fund, acceptance or utilization of the fund, and foreign hospitality for any activities. So this required the NGO that is to apply for the license to receive the foreign funding, and that is NGO must be existent at least 3 years. So at least 3 years NGO must be there, at least 3 years, and spending at least 1 lakh over the 3 years. So okay, 10 lakh rupees at least 3 years. So they are applying 10 lakh rupees in the 3 years, and it must have undertaking the reasonable activities. NGO with permanent license now have a renewed every 5 years, and they should be renewed at the 5 year. 5 year में इनका renewable होना चाहिए. NGO shall not spend more than 50% of the foreign contribution received in the financial year to meet the expenses without prior approval of central government. So 5 ईयर में जितना भी मनी वो खर्च करेंगे, अबाउट 50% ऑफ मनी वो सेंट्रल गवर्नमेंट को दे आर जस्ट बताएंगे, ठीक है. सो रिसेंट चेंजेस आर गवर्नमेंट बेयर्ड सेवरल प्रोमिनेंट NGOs and file their annual returns for the 5 consecutive year. NGO are required to validate the bank account in which they are receiving this fund, and Ministry of Home Affairs issued the circular. So who will going to be issue the circular? First is the Ministry of Home Affairs. Ministry of Home Affairs is there, and it will issue the circulars for the NGO registration under the NCRA Act, and should be receive foreign donation in the single design bank account, single designated and bank account, that should be in the single designated bank account. Individual has not been involved in any act of the religious conversation or the prosecuted criminal disharmony. And Foreign Exchange Act, that was FEMA Act. FEMA Act is, it was introduced, consolidate, amend the law relating to foreign exchanges, for the consolidate the act. So FEMA is for the consolidate, for the consolidate the money which is relating to foreign exchanges. And certain NGO are the registered under the FEMA under in the Ministry of Finance, and that is under the Ministry of Finance. But FCRA is under the Ministry of Home Affairs, but that is FEMA is under Ministry of Finance. Other regulations are the labor laws. Other regulations are you can see the labor laws. So you can see the labor laws. Okay, this is about the NGOs are the 20 employees apply for the employment provident fund. And accreditation is recently accreditation guidelines are given. That was the Vijay Kumar committee. That was about the Vijay Kumar committee. Niti Aayog has been appointed the nodal agency for the registration of the NGO, and the Niti Aayog is about the registration of the fundings from the government. Okay, so what is the RTI and the judiciary? What is the RTI? RTI Act was conferred the power Chief Justice Supreme Court of India and the Chief Justice of High Court, Chief Justice of the Supreme Court plus the Chief Justice of the High Court, and that is carrying out its provisions like Supreme Court rules undermine the RTI, unlike a time frame for furnishing the information, appeal mechanism, penalties and delay wrongful refusal, make the disclosure of the citizens. RTI Act does not permit any appeal, but Section 23 is the power to Supreme Court and High Court that override. So Supreme Court has said the decision of the Registrar General of Court will be final. The Registrar General of the Court, and that will be the final decision for the RTI. Okay. Now Protection of Human Right Act 2019. Next is the protection of the Human Right Act, and that was in 2019. So President gave assent to the protection of the Human Right Act. Okay, and this is about the National Human Right Commission denied the A grade accreditation and globally aligns National Human Right Constitution under the UN body, and that was a Geneva is the commission failure in ensuring the gender balance and the pluralism. Lack of transparency is there, so we need to reduce the increase the transparency. First is the Paris Principle. What is Paris Principle? This is about the provide the international benchmark for the national human right. This is providing the national human right benchmark. Okay, and that is able to advise the government a specific violation, implementation of the human rights, be able to relate to regional international organization, educate, inform, and some institutions should given a quasi-judicial competition, and that is a quasi-judicial competence. Now next is the amendment of the original act, that was composition. Under the act, chairperson is a person who has been a Chief Justice of Supreme Court. It provides for 2 persons having a knowledge of the human right appointed by this. Under the act, chairperson of various commissions such as the National Commission for Scheduled Castes, Scheduled Tribes, and the National Commission for Women Under the act, the chairperson is a person who has been a chief justice of the high court. The act states that the chairperson and member hold office for the 5 year till the age of the 70 year, 5 year and the 70 year. And further, the act allow for the reappointments of the member of NHRC and SHRC for the period of the 5 year, and they are allowed for the reappointment also. Okay, so that was the old act. Now in 2019, the changes was in National Human Right Commission. First, it is amend the provide person who has a chief justice of judge of Supreme Court will be the chairperson. It amend to allow the 3 member, and there is a 3 member now. Before that, there was a 2 person having a knowledge. Now there is a 3 member, at least one who is a woman, and one will be the woman, and presently one is a woman. Okay, it provide for the including chairperson of the National Commission for Backward Classes, National Commission for the Protection of the Child Right, एंड नेशनल कमीशन ऑफ द डिसेबिलिटी, चाइल्ड राइट्स एंड डिसेबिलिटी वाले जितने भी पर्सन है इसमें से भी एक पर्सन होगा. ठीक है, इट अमेंड टू प्रोवाइड द पर्सन वो हैज़ बीन चीफ जस्टिस ऑफ द हाई कोर्ट विल बी द चेयरपर्सन ऑफ SHRC. SHRC में कौन होगा, जो कि वो विल बी प्रोवाइड द पर्सन वो हैव ए चीफ जस्टिस ऑफ हाई कोर्ट ऑफ ए, जो कि पहले हाई कोर्ट का चीफ जस्टिस रह चुका है. रिड्यूस द टर्म ऑफ ऑफिस, दैट वाज बिफोर दैट इट वाज 5 year, नाउ इट इज़ 3 year, and age of the 70 years. Okay, now remove the 5 year limit for the reappointment, and that reappointment limit is also removed from this. It provides that central government may confer the state government for the function being discharged by the union territory, and what functions are discharged by union territory, that will also be decided by this. Okay, so this is about the National Human Right Commission.